series. This webinar is called Record Retention and Litigation Preparedness, Harnessing Business Value and Being Compliant by Knowing Where Your Business Information Is. We want to give a big thank you to HP and NextPage for sponsoring this webinar series. My name is Lisa Berry Taman. I'm a senior consultant with Con Consulting. I'm an attorney as well as a certified information privacy professional, a member of ARMA, and I do some guest lecturing at Indiana University, Purdue University, Indianapolis. I'm very happy today to have joining me John Collins. John Collins is the founder and vice president of consulting services for the Ingersoll firm. The Ingersoll firm provides electronic discovery consulting, and they are the leading ESI data mapping consultants. John is an interesting fellow. He has both a legal background in that he graduated from law school as well as an IT background. Kelly Twigger is a former partner at Quarles & Brady. She just recently formed ESI Attorneys, a new law practice devoted to assisting clients with managing their electronic information and e-discovery issues. So please take note of her new email address and give her a call if you have any of those types of email and e-discovery issues. Let's go ahead and get right into our presentation today. What I want to talk about is the issue of too much information. In 2007, there were 281 billion gigabytes of information, and it's estimated that in 2011 there'll be 10 times that figure. So why am I telling you this? Well, as I said, that's the issue, too much information. If we were in a person-to-person type setting, I would ask you to raise your hands if you felt like your business was retaining too much information or retaining all of its information. And I'm sure there would be a number of people that would raise their hands to that question. There are lots of problems with retaining too much information for a business or organization. You end up with increased costs, efficiency issues, lack of compliance, increased risk, and then the whole topic of e-discovery and legal issues if you're ever required to produce that massive, too much information. And Kelly's going to go into that further later in her part of the presentation. Information is growing so rapidly that there's really no way to be efficient if all the information is kept given the growth rate of the information. What I plan to do for the rest of my portion of the presentation is talk about a solution, a way to winnow down that too much information and help your business harness the business value of its important business content. So how do we do all those things? How do we know where our business content is? How do we harness our business value? And how do we be compliant all at the same time? Well, you can do that through your records and information management program. And more specifically, what I'm going to focus in on today is the record retention schedule. A record retention schedule is a list of records that need to be retained to satisfy various business, legal, regulatory, or compliance requirements. It defines how long those records need to be retained to satisfy those requirements. And it helps you manage those records systematically. Now, you're not managing everything. You're managing records. And records is information that's on some kind of tangible medium that's intentionally retained and managed as evidence of your organization's activities, its decisions, its events, its actions, transactions, because of its ongoing business, operational, legal, regulatory value. And you're being compliant with all of this because you are following the record-keeping guidelines in accordance with the laws and regulations. What I want to do next is to show you various types of record retention schedules. The first one I want to show you is called a records list. A records list, and let me minimize this for you so you can see the whole list, and we are focusing in on payroll records for all of these examples. But you see you have a record name and you have a final retention period. There's some pros and cons to this type of record retention schedule. The first positive to it is that it's very simple. The negatives include the fact that the terminology may not be familiar to your end users. You usually have too many permanent retention periods, and you can actually see that in this example. And you do not know where the records are located or on what media. So let's look at the next type of example I have here, which is the departmental schedule. The departmental schedule, again, will have a record name. Usually it will have a record description that tells a little bit about the purpose or the use of that type of record. Many times this type of departmental schedule will tell you the media or the record custodian. This one does not. This one shows the legal research over here under statute. This one only gives you the final retention period, but many departmental schedules will give you not only the final, but it will give you what that's made up of, which is your legal retention period, what the statutes and regulations tell you, and your business retention period, which is how long do you need for your own business needs to retain that, and that's what normally you'll see. You'll see 3 different retention periods and then this final. Again, there are pros and cons to this type of schedule. One of the positives is you're using terminology that it's familiar to your end users. It contains the legal research, and many times you can document additional information about those records. For example, with this particular example, it has classification, and it's telling you whether the records are private or public. The negatives, this type of schedule can be very difficult to maintain because there can be thousands and thousands of categories of records. For example, you can see already with this particular record retention schedule that there are 66 pages of a list of these kinds of records. The record retention periods can end up being the same, can end up being inconsistent for the same kind of records, and it can be, overall, it can just be difficult to understand and comply with. I most often see this type of schedule with government entities. All right, let's go to the next one. The next one's called a functional schedule. This one's called functional schedule with record examples. On this one, you're going to see there's the function, which is accounting payroll. The rule name is payroll, and there's a description. What it has a list of record examples. All of these types of records, instead of being individually listed like we saw in the departmental schedule, are actually all tied into this one rule. We see the legal retention period, operational retention period, and then the final retention period, which is the longer of these two. We also see the legal research. Again, pros and cons to this type of schedule. A big positive is there's consistent retention periods across your entire enterprise, and your legal research is tied to your functionality. Some negatives are it may be very difficult for your users to understand or to know what records belong to what rule because you're not giving an all-inclusive list of examples. Also, it doesn't tell you who the owner of that record is or its media or its location. The last record retention schedule example I'd like to show you, to me, is the best of all worlds. It's a functional schedule with a detailed departmental inventory. And what that is, it's very similar to the one I just showed you. You'll see the rule name, but tied to that rule name are all of the different types of records that have been identified by the organization through an inventory process where you ask people what type of records that they have. And because of this inventory, you can do various things. You can actually put additional information in about each inventoried record. For example, with this record, monthly payroll registers and reports, you can put additional record descriptions about it, privacy, security, what media it's located on, and if there are any third parties that are holding that data. Again, like I said, I think this is the best of both worlds because you're allowing your users to use what they call the big bucket retention method in retaining. So instead of having thousands and thousands of different categories, you have maybe 100 different rules to deal with, but yet you also have that granularity for that record retention schedule. Again, there are pros and cons to this kind of schedule. The pros, it's consistent retention periods across the enterprise. Your legal research is hooked to your functionality. Users have a retention schedule, their own retention schedule. For example, maybe the accounting function would have this particular rule to deal with. And you also, like I said, and showed you have all this additional information that you can cover. The negative is that inventory maintenance can be burdensome unless you assign it to each group or each function to kind of have responsibility to keep up with that information. All right. Since I'm not giving you copies of those particular schedules because some of them contain proprietary information, I did provide you with a table, which I'm showing here, which lists each type of schedule and then the components that are most normally found within that kind of schedule. So hopefully that is helpful. Why should you do all this? Why should you go through a records retention program? Why should you have a record retention schedule? Because By being able to locate business records, you can harness the business value of that information. There are lots of pragmatic benefits. I want to go over those quickly. Efficiency increase, your ability to find the information that you need. Retention is really the only way to clean house and do it with an eye towards business efficiency and legal compliance. It helps you with your business purpose. For example, if you receive a request from a customer and you can't find that request, it's really hard to respond to that customer, and that is part of your business purpose. It helps you with loss prevention. You know where your trade secrets are. You know where this quote-unquote secret formula is, and you can protect that. You can limit access. And you also have a better idea if someone's taken that information, which is a big issue, unfortunately, in this economy with all of the layoffs. People have walked out of their companies with entire client lists, which is a big loss to the company. You can protect your private information for both your customers and your clients. You know where your information is that contains personally identifiable information. At last I checked, per record breached costs about $179 per record, and that's an average. So for a small company, let's say you've breached 1,000 records, we take that times 179, or as we've seen in the news with some of the bigger breaches, it could be millions of records times $179 approximately. Dispute resolution. It's really hard to argue terms of a contract or to hold somebody to the terms of a contract if you don't have a copy of that contract, if you can't put your hands on it. Regulation compliance, you're abiding by record-keeping requirements by having a record retention schedule, and if you have one that actually has the legal research, you know that you're complying with those particular statutes and regulations. Litigation preparedness. I've been saying now for a number of years that if you do things right on the front end, which is records management, records and information management, it comes out better on the back end of e-discovery. I'm not going to go into that too much because, as I said, Kelly Twigger later in the presentation is going to talk about that issue. The last pragmatic benefit I want to talk about is competitive advantage. By having better ready access to your business information, you can get a competitive advantage because you know where your business stands. You know how well your business is doing and what it can take to continue doing well. And that's especially important in this economy. I want to go over quickly some strategic benefits. Because you can find your information in different formats, you can actually aggregate that information to make determinations such as pattern assessment. With a pattern assessment, you can determine if maybe your customers are buying certain things in certain parts of the year, and you can make business decisions based on that information. The last strategic benefit, which I think is very important, is innovation. If you can't find your information, you can't build off your information, and it's very difficult to innovate. And in this environment, in this economy these days, it's really important that we can identify our vertical markets in different businesses. So I'm going to leave you where I started, which is the whole thought that businesses have too much information.
I can. There we go. So we're delighted to be part of this webinar series, to be participating with Lisa, Kelly, and John, and also with our friends at HP. I thought I would start my brief portion of the webinar by providing some of the analytics that we have created as we have worked with different customers in this space, solving the very problems that Lisa was just talking about. This is an interesting slide in that on the left, the pie chart is really about where is this, what Lisa referred to as, where is the too much information in your enterprise? Where does it actually exist? And then on the right-hand side of the slide with the bullet points, those really get to the specific costs around how much does it actually cost large enterprises to have that information sitting in those places. What we have learned when we put our analyst hat on is that actually a very small percentage of the overall amount of information stored in any enterprise is actually a record that you are legally responsible to keep. The percentages for your organization might be different, but in most cases across the customers that we've profiled, the actual records themselves amount to about 5% of the information that's laying around in the organization on desktops, shared drives, and in other repositories. Now, when you move back from the records that you are legally obligated to store, protect, and keep under the constructs of a records management schedule that Lisa was just talking about, you get to another category, which is there's roughly 15% of the information out there that you need to run your business, but that's not necessarily a record that you're legally responsible to keep. So these could be the kinds of files that get used over and over again in the course of doing business that people need every day to do their jobs. And when you look at that percentage, it's roughly around 15% of what's sitting in the enterprise in these various locations. But by far, the vast amount of the information that's out there is stuff that is irrelevant, it's stuff that's outdated, it's stuff that's been superseded by other information, yet it continues to sort of just languish out there in electronic form on shared drives, on desktops, etc. It's consistently backed up, even though there's really no need to back it up, etc. And ultimately, it costs the organization lots of money. If we look quickly at costs, simply storing this information is expensive. So as Lisa mentioned, the costs continue to go up because more and more information is stored. In the customers that we profile, the storage costs are doubling roughly every 3 years. The cost of the storage itself is cheap, but when you take the cost of managing the storage, feeding the storage animal, backing it up through different tiers, etc., you still have costs that are outpacing the reduction in the actual devices themselves. So the status quo cost that we came up with across the customers that we've talked to is about, the status quo cost is about $24,000 per terabyte of unstructured information. That's what it costs just to keep out there and keep backing up and keep archiving, etc. If that same terabyte is ever subject to e-discovery, that same terabyte of unstructured information, documents sitting on shares or desktops, the costs go up dramatically. And across the customers that we profiled, we see that those costs will go to anywhere from $1.5 million per terabyte to $4 million per terabyte. So real costs associated with too much information laying around in the enterprise. And then additionally, you, in large enterprises here, in business in the United States, are under increasing obligation to get your arms around what you have and manage it effectively. That's another force that plays into this equation. Federal Rules of Civil Procedure, there's risks to your reputation in terms of having this stuff laying around forever and ever, not managing it proactively. So quickly, let me just tell you a little bit about how NextPage addresses the problem. The first thing I want to say, the important thing on this slide, is that with NextPage, you're not actually getting another repository or place to put records. There are many, many really, really good records management systems and repositories on the market, some of which are available through our partner, through HP, who's also participating on this webinar. What we do at NextPage is uniquely identify any file regardless of its location. So if it's sitting on a share or a desktop or an email, NextPage can give that file its own unique identifier. And then as people work on these files and they begin to proliferate and move everywhere through the enterprise, our system can track them transparently. It's also possible to get classifications on those files. Once a classification is associated with a file, it will automatically move around with the file as it proliferates and grows and expands into multiple copies throughout your enterprise. With the classifications on the file, you can then actually create policies that go out and act on those files. We call this overriding system a digital threading system. And what the digital threading system allows you to do is to uniquely identify anywhere on the thread where the golden nuggets are that need to be put into a records management system so that they can be kept in accordance with the records management schedule that Lisa was talking about. But then just as important, once that golden nugget record has been put into the repository, you can use our system to look back through that thread and automatically delete or remove all of the previous irrelevant versions of that file that might be laying around on shares, desktops, or in email, so that you're now consistently reducing the pile of information that's out there that needs to be proactively managed in the organization. So again, we feel that we were excited to participate in this webinar because we feel that the technology that we have actually suits this particular problem extremely well, and we look forward to talking to any of you who may have questions later on. So with that, I will transition this over to Kelly Twigger.
Kelly, is your phone on mute?
Can you hear me now, John?
Yep.
Yeah,
Okay, sorry about that. Yes.
No problem.
Thank you. My phone was on mute. Sorry, I was talking for 5 minutes. Thanks very much, James. Apologize for the silence there as I was muted so as not to disturb the other presenters. I wanted to sort of add with what James was saying and some of those numbers that he had raised about the $24,000 to store and manage the information at a terabyte, and then the $1.5 to $4 million. Those of you out there who are trying to work within your organizations to be able to perhaps justify, a RIM initiative to be, and in fact, I was just asking James about those this morning. So from that, let me transition into my part of the presentation, which is really to say, okay, we've talked about records management. John's going to follow up on some other issues after my presentation, but how are judges perceiving these programs, and what are judges requiring of organizations? We've now we're 3.5 years into the amendment. How are these programs being? My new firm that I just formed called ES Legal Advice. Matters per se, but simply helping to manage the electronic discovery issues within the context of the matter. We also provide to clients an assessment of the policies and practices relevant to electronically stored information, and within that assessment, we'll give you organization-specific recommendations for vendors and anyone else, any other items or consultants or things that we think would bring value to your organization. In some instances, vendors can be very useful. In other instances, organizations aren't in need of any outside support. They have what they need internally. We do RIM initiatives and work with the day-to-day assistance of managing electronically stored information. We also do training programs throughout the country for attorneys to help them understand the technology and to how are judges viewing these programs. And one of the things that it's important to think about is that spoliation, which is the destruction of evidence, has been a concept around for many, many, many years, and it's always something that judges have taken a very harsh view of. And I think this quote that's out here from the United Medical Supply case really puts it in perspective. And in some instances, as we'll go through a couple of the cases that I pulled out for us to discuss today, you'll see that it seems like the sanctions that are handed down are rather harsh, given perhaps the availability of the electronic information from another source. But judges are treating the destruction of electronically stored information very harshly. And what they're saying now is that we've given you notice. You've had 3 years of these rules being out there. There is a plethora of case law out there to discuss them, and you need to get a program in place, and there is not going to be any excuse for you not being able to manage and preserve your electronic information. So let's dive into some of the cases. Now, before we start, we'll talk quickly about the safe harbor provision, then the 3 cases that I picked out, Henry Riverside Healthcare, Connor versus SunTrust Bank, and the highly controversial Philip Adams case, and then cover some of the lessons that we've learned from there. But I want everyone to understand, and I know this is a constant theme when discussing electronic discovery case law, but these are all discovery disputes, and discovery disputes in their very nature are very, very fact specific. So when you're conducting an analysis of e-discovery case law and you're considering applying it to your particular situation, you need to make sure you've got a good understanding of the background and also the facts and what are the issues inherent in your case prior to applying this case law. Now, Rule 37 of the Federal Rules of Civil Procedure contains subsection E, which is widely referred to as the safe harbor provision. And the safe harbor provision in Rule 37E discusses the notion that a party who deletes electronic information or the unavailability of electronic information is related to the routine operation of an electronic information system is considered to have done so in good faith and would not be subject to sanctions. But the question then becomes, what is the routine operation, routine good faith operation of an electronic information system? And the pictures that you see on your screen, really, you want to be on the left-hand side. You want to be with your sailboat that is your organization in nice, calm waters, safely in the harbor, tooling around, handling your electronic discovery issues as smoothly as anything else. You don't want to be on the right-hand side, where you're in a storm, everybody is scrambling to figure out the best way to keep your ship afloat. How to do that? You need to get a process in place to manage your electronically stored information. And that includes email, that includes records that Lisa was discussing at the beginning of our webinar today, and it includes all the information in your organization. As James mentioned, there is probably somewhere between 5 and 20% of the information in your organization that actually needs to be retained legally. The rest of it is business preference. Okay, jumping into the case law and what courts are saying. In the Henry Riverside Healthcare case, Riverside Healthcare operated a nursing home, and Cisco, which is a large food distributor, supplied food and products to the nursing home. Well, given the economy, the nursing home went into bankruptcy, and the question really before the court was whether or not payments that were made to Cisco from the nursing home were within the preference period, such that if they were within the preference period, then Cisco would have to return the payments to the nursing home. And the e-discovery issue in the case really boiled down to whether or not email was routinely deleted as part of the good faith operation of an electronic information system. And all the correspondence between the customer sales representative at Cisco and at Riverside with the nursing home at Riverside was done via email. And by the time the suit was brought, and notice was given of the suit in terms of a letter, all of the information, all of the email that was pertinent to that account and on those particular payments had been deleted as a result of the 60-day system-wide deletion on email. And so there was testimony that that email was routinely deleted before any notice was sent, and based on those facts, there was no prejudice, according to the court. The court also did note that the lack of effort by counsel on behalf of the bankrupt client, Riverside Healthcare. Basically, their failure to try and go and get any email initially really weighed against the court issuing sanctions in that case. Okay, moving next to the Connor versus SunTrust Bank. This is a situation in which an employee went on FMLA leave, and while she was on leave, one of the people under her management left his job, and he was in another location where there were also 3 other people that she managed. And as a result of that supervisor leaving, the employer decided to shift some things around, and 2 weeks after the employee came back from her FMLA leave, her position was terminated. And she sued almost immediately. Within 5 to 10 days of being terminated. She sued for wrongful termination, alleging that she was fired as a result of taking her leave. And just like in the In re Riverside case, the timing of this case is very important. There was an email that was sent by the employee's supervisor on February 12th, and on February 22nd, the employer received notice of the lawsuit. The employer's email system overwrites after 30 days, but according to the timing, the email that was sent on February 12th would have still existed 10 days later when the notice of preservation came out. The notice of preservation was circulated to the supervisor, and when she produced email on her own from her email account for the litigation, she neglected to produce the February 12th email. Apparently her practice had been to archive messages, but there ended up to be a 6-week window, notably right around this time when this decision to fire this employee was made, where that email was not available. And the question here really starts to be, is there a good basis for allowing your custodians to gather their electronic information and provide that to counsel, rather than counsel going and understanding the sources of the information and determining what information needs to be pulled for preservation and then culled down for review and production. And I think this case really started to raise that issue, and we're going to talk about it, that it comes to a more dramatic point in the Philip Adams case in just a minute. And so one of the big issues here, though, is that probably 85 to 90% of organizations out there allow their custodians to do self-collection, and is that really going to be a good practice going forward? Sanctions were issued in this case. Okay, so taking that case, we're going to move on now to the Philip Adams case. And the Philip Adams case is a very highly controversial case at this point, simply because of the facts. And this was a dispute that centered on alleged infringement of several patents that were developed to resolve defects in floppy disks in the late 1980s. And this is a case that starts out as a preservation case but moves quickly into discussing the policies and practices of managing ESI. This is a situation where ASUS, who was the defendant, allowed its employees to manage their own electronic information. There were no policies, no records retention policies, no email deletion policies, no policies at all on managing ESI in place at the organization. And ASUS attempted to seek refuge in the safe harbor provision of Rule 37E by stating that the information that the plaintiffs claimed it should have preserved was routinely deleted by its custodians. And the court looked at the lack of policies and the fact that the custodians were responsible for simply basically making up their own policies, and said that it was unreasonable to have custodians be responsible for compliance without policies or procedures in place, and that he refused to apply the safe harbor. He also identified that ASUS had no centralized storage of ESI and relied solely on employees to archive email, and other ESI resided only on the desktops. So, the Adams case is from a records management perspective and an ESI management perspective, and I use those two terms differently because ESI to me encompasses all electronically stored information. So all email, all information that's created that's not a record, plus all records. That to me is all ESI. it's really important now that organizations get a process in place for managing that information. It's going to be organization specific. It's not necessarily going to be as broad-reaching as a Fortune 25 company that has 60,000 employees across the world. But it's important to realize that the case law is expanding to evaluate these policies. So what do we take away from this case law? Get a process in place for your organization. Assess where your organization is right now and where you want to be. Do you want to be facing a motion for sanctions or a motion for spoliation for electronically stored information? Evaluate custodian-based management of ESI. How much risk do you want to take on? What do your policies and practices look like? Make sure that you're incorporating a training element to whatever RIM initiative you're undertaking so that your employees know what their responsibilities are. And that policy needs to be in place for managers as well so that they can be sure to be instituting compliance within the organization. So for those lessons, now I'm going to turn it over to Mike Peebles of HP. So Mike, let me transfer over the screen here.
Okay, very good. While Kelly's doing that, my name is Mike Peebles. I'm a product manager with Hewlett-Packard's in the Information Managed Business Unit. And where we focus our solutions on is helping organizations be litigation readiness, whether it's for their business records or other data within the organization. Getting those tools put into your toolkit so you're ready for litigation that may happen in the future. And we look at the electronic discovery reference model. We see, we look at it, there's a joint responsibility between IT and legal, and depending on the type of organization and the type of lawsuits you have, there's a varying degree of responsibilities based on the EDRM model. But what we give is, these tools to help those organizations and this cross-functional team work together and implement, a repeatable process that helps you get your digital house in order. And as Lisa mentioned before, it also helps you get the benefits by implementing this, not only for e-discovery, but the rest of your business gets benefits out of this as well. And if we take a look at some of the things that, some of the benefits, by the EDRM model, so obviously some of the solutions that HP provides enable you to set the retention, implement that, but also, reduce the volume and reduce the storage costs associated with that data, and that really happens out in information management. But it also helps the rest of the organization, like your knowledge workers, get business context and insight out of the data that's there. They know which is the authoritative version of a document, et cetera. If we look at over in the identification phase, it obviously helps with faster identification of the data and getting more relevant identification of the appropriate document. And the other thing it helps is, by putting litigation holds on documents in place, but also from a process perspective, it allows, whether it's the record management or IT or legal organization, to remove responsibilities from the individual custodian and centralize the litigation hold. So once you know what type of data needs to be put on hold, it's to centralize that whole process. So you don't have to rely or put that responsibility on the responsibility of each, or the individual shoulders of each custodian, so you can centrally manage that and make it a much more manageable process. And then also helping, with early case assessment, figuring out what data is in your environment, how much you have to work through, and sort through that data more timely manner so you're ready for those very early meet and confers. And so if you look at some of the products that HP is available, on the information management and identification phase, we have a documents and records management solution called HP Trim Software. And it really is just a records management solution, enables the retention time to be set. And then also we have the integrated archive platform that is with compliance archiving for so doing the search, doing the management of data and high volume data, and then legal analytics with a Clearwell system. So it enables you to cull down the amount of data and show so you really can focus in on the documents to what's appropriate. And so with that, I am going to turn it back over to John.
Thanks, Mike. This is John Collins with the Ingersoll firm, and I'm going to go ahead and share my desktop. And you all should see my first slide. What I'm going to talk about today is the challenge of deciding how in-depth an organization's knowledge should be about where its business content resides. And what I'm going to do is look at this primarily from a litigation and compliance standpoint, but as Lisa pointed out, there are some key issues to also consider from the RIM dimension, but we don't have time to delve into all of it today. So here's what I'm going to try and cover in the next 15 minutes or so. First, I'm going to touch on the concept of what might constitute a reasonable good faith effort as the litigation and compliance touchstone for deciding how deep to delve into the whereabouts of ESI or information, and I'm using those terms interchangeably. Then I'm going to go ahead and look at the challenge of understanding the potential storage locations for data or information or ESI. And I'm going to do this in the context of reasonable good faith again and try to point out some of the extremes of understanding that might exist and make some humble observations from my perspective as to what might constitute a reasonable good faith effort to understand where ESI resides. Then I'm going to offer a methodology for determining how an organization might go about determining the level of detail in which to delve regarding where their ESI resides. And then I'll show some examples of how to gather an appropriate level, what might be an appropriate level of detail about where ESI resides and how to present some information. So with that, what constitutes a reasonable good faith effort in terms of understanding where an organization's ESI resides? Now, at one extreme, you might have a situation where counsel, inside counsel, outside counsel, don't understand where the basic locations are to look for potentially responsive information. Now, in the paper world, not looking in a filing cabinet or on a custodian's desk or in a custodian's desk, I'd like to suggest that in the electronic world, counsel not knowing that a particular custodian's email might reside on both an email server, you can see the Exchange server there, and on a custodian's computer, and what resides on one or the other may or may not be identical. They're, not understanding sort of that basic fundamental concept that there is information both on a server and on a desktop, and what's on one may or may not be on the other. I think, reasonable good faith effort, counsel should understand these basic dynamics about electronically stored information and how it's managed. So I guess the question I would put out to folks listening is, how well do you understand how email is stored and managed within your organization? Now, at the other end of the spectrum would be, in the context of reasonable good faith, what's too much information? What constitutes too much information? Here's a visual depiction of what's going on a Microsoft Exchange email server. And there are a number of things here that are just not even remotely related to how information is stored on the server or how it's managed, but they're critical functions in terms of making sure that the email gets from point A to point B. So things like NTLM, security support provider, remote procedure calls, security accounts manager. These are things that are not really necessary for counsel to understand. But there's one element on this slide that is absolutely critical, and that would be the Exchange information store. And I think this graphic illustrates really well the challenge that we have regarding what constitutes a reasonable good faith effort to understand where and how IT systems store and process or manage ESI. Most of the information here is highly technical and not really related to how the information is managed, but there is this one element that is really key, And I guess the thing that I want to put out there is that when it comes to understanding where your organization stores its information and how it's managing it, it's one of those situations where the technology knowledge that the people that are dealing with these issues, whether you're a records manager or an attorney or paralegal or legal professional, is that you really need to have knowledge that's a mile wide and an inch deep for many things. But for some things that are critical and key, like the Exchange Information Store, you not only have to have that mile-wide deep knowledge, but I think that you have to also have mile-deep knowledge about that. And it's not easy to get there, but I think that's in part why consultants such as myself and Kelly and Lisa are in business. This is a screenshot that illustrates one of the mile-deep areas of knowledge that I was referring to, which is understanding how an Exchange server manages email and how the organization is managing email. Now, you can see here I've got in a box deletion settings. And this particular configuration option on an Exchange email server can have a significant impact on what email is available within an organization. You can see that there's a setting here that says keep deleted items for X amount of days, and you can enter the number of days that the deleted information is retained. You can keep deleted mailboxes, so when somebody leaves an organization, mailboxes can be preserved. Now, one of the key dynamics here is what is going to make it onto a backup tape. So even if an employee were to delete an item on a Monday, if these settings are configured in a certain way, even though the employee has deleted that email is going to make it onto, in many instances, onto a backup tape. And if the organization doesn't have good, solid rotation policies around backup tapes, they may be preserving email far beyond what they have to. So I think it's key to understand that there is, if we go back, there is too much information, but then there's the concept of not having enough information, and then what constitutes the right amount of information, what's reasonable. Now, to try to put this into perspective, what I'm going to do is walk through this slide very quickly, but this is a slide that I use to teach Microsoft Exchange and Outlook to records and legal professionals. And the basic idea here is to illustrate the different locations where email can be found within an organization's infrastructure. So you've got Exchange servers, network file shares, you've got the Exchange or email server itself, you've got the user's desktop, and then depending on the configuration options that have been selected, you could have email that's on DVDs, archive files, or what are also known as PST files. Of course, we have backup tapes. And then you can have loose email really anywhere throughout the organization. But whether or not some or all these locations are actually going to be at play in a particular organization is going to be based on how they've configured the email server. And sort of like Kelly was alluding to earlier, I was thinking that in the same vein that a lot of times when you look at the case law, it's very fact specific. Well, I think when you evaluate how an organization is managing its ESI, it is also very fact specific. It's very configuration specific. And the way that one company has configured their email system may be significantly different from the way another company. So there's not you can't look at one organization and another and say, oh, I know how this organization manages their email, so it must be very similar at this other organization. Some companies I've worked with don't allow PST files at all. Other organizations that I've worked with will allow PST or archive files to proliferate throughout the organization pretty much at will. So taking a step back, how does an organization at the front end determine what level of detail in which to delve regarding where their business content or ESI resides? And what I typically will do in working with a company is we'll take a look at their litigation portfolio. Again, we're looking at this from the litigation compliance standpoint. And the in-house counsel, records department, and other stakeholders will go ahead and develop a list of categories of information documents that are requested most frequently in litigation or investigation. So, for example, I've done a significant amount of work with manufacturing companies, and in those companies, their primary risk and their primary type of litigation is products related or products liability. So what they'll do is they'll go through and looking through various complaints and other documents that they've received over the years, come up with a list of different types of information that are typically requested. And what I'm going to do is jump over to a sample document and just run through this quickly. So this is an example of the types of documents that this manufacturing company has been requested to produce over the years. Now, through a data mapping process, what I was able to do was go ahead and work with them to map the ESI locations to the document category and to the specific document types. Now, in a products liability setting, you can see the types of things that this organization identified were things like application development and research, correspondence, customer complaints. Well, probably the key area that this organization focused on and wanted me to focus on from a mapping perspective to understand where their information is and how it's managed are design specifications, so CAD drawings, engineering information, engineering change orders, etc. So once the organization has identified the key types of information that they're most frequently requested to preserve and produce, you could then map the IT systems and prioritize the IT systems based on the relevancy to the type of litigation that the organization has, and basically match the applications and systems with the various information categories. So what I'm going to do is jump over to an actual data map and show you in this particular organization where we prioritize the data into Tier 1, which is those systems, IT systems and applications most relevant to litigation, and then Tier 2, those systems that were less relevant to litigation. So if we go to Tier 1 and scroll down a bit, you can see the list of various applications. I'm going to jump over to one, Adobe Illustrator, and you can see the depth of information that we decided to collect. When was the system first deployed by the company? Where is the data stored? What is the native file type? Has there been any system-wide purging or deletion? And then is the system backed up? And you can see that we have a detailed explanation in terms of how the systems are being backed up and then who are the system's users. So from a prioritization standpoint, this is a Tier 1 system that's very relevant to litigation. If we jump back and look at the type of information collected about Tier 2, it's not nearly as in-depth. So we basically have the system's name, what the system does, who the users of the system are, and then who the particular IT contact is. So how do we get this information? Well, what I typically do in working with my clients in building a data map is use a series of questionnaires, surveys, and interview techniques to gather the information to make sure that the data map is defensible, that we're getting accurate information about the IT infrastructure. This is a survey of the various IT systems and software that the organization has deployed. Once we've winnowed that down and we understand what the Tier 1 and Tier 2 systems are, then we start to gather detailed information about the Tier 1 and Tier 2 systems. Now, certain Tier 1 systems may not require as much information as other Tier 1 systems, so I tend to think of it as sort of a Tier 1A, Tier 1B type of approach, so even a kind of a sub-tiering. So this is a worksheet that I'll use to gather information about that Tier 1B, and you can see when was the type of information that's being gathered, when was the system first deployed, where is the data stored. Now, for systems that are super high profile, the Tier 1A systems, so I guess you could think of it, I use much more detailed worksheets which get into the historical dimension of the system, when it was deployed, and then some key configuration questions. This is talking about cached exchange mode, which is one of the factors that determines whether or not email may or may not be on a particular custodian's desktop or laptop computer. So this is how I gather information about the super high profile, what I think of as that Tier 1A type of system. And then lastly, just to bring it back in conclusion, what the ESI data map looks like, and I think my screen may have frozen. Let's see if we can get that to, I can fix it here. Here we go. So going back to my main screen here, when I present the information, it's presented in the ESI data map, and what we can see here is the way this is broken down is we have a master inventory of all the IT systems broken down into their priority from a prioritization perspective based on their relevancy to the firm's litigation and risk management portfolio. Then we have a detailed breakdown of their email system, detailed breakdown of file servers, detailed breakdown of the organization's ERP system, which in this case is SAP, detailed breakdown of the organization's legacy systems that are still within the organization's IT infrastructure, and then a directory of contacts, which is a comprehensive list mapped to the particular systems that the IT individuals have responsibility for. With that, let me jump back over. And I want to thank everyone for joining us today, and Kelly, Lisa, James, and Mike. We are going to have an extended question and answer. If you have any further questions of any of the speakers, here is our contact information. Please feel free to drop us an email, and I'm sure we will get back to you as quickly as possible. So with that, I want to thank everyone, and this concludes our webinar for today. Thank you.